In early July, the conservative majority on the Supreme Court decided to grant presidents and ex-presidents immunity from criminal prosecution for anything they do that could be construed as an official act, leaving one big question. Could the criminal cases against Donald Trump still proceed? Well, today, the special counsel Jack Smith filed a superseding indictment in one of those cases, his criminal prosecution of Donald Trump over his alleged attempts to overturn the 2020 election. The new indictment refines the special counsel's original argument in an attempt to put it in compliance with the Supreme Court's decision. The new document adds language highlighting the personal nature of some of Trump's alleged election interference attempts, including the use of his Twitter account. Smith also edits out some of Trump's actions included in the original indictment, actions that occurred in the Oval Office. And they remove former Assistant Attorney General Jeffrey Clark as an unindicted co-conspirator altogether. But one thing that hasn't changed, the charges. The new indictment charges Donald Trump with the same 4 criminal counts as the original. So what's different? Well, joining me now is Mary McCord, former Acting Assistant Attorney General for National Security at the United States Department of Justice and co-host of MSNBC's Prosecuting Donald Trump podcast. Mary, good to see you. And I need you to tell me what's different, what's the same, what's happened.
Well, as you were just indicating, what the Department of Justice has done now through Special Counsel Jack Smith is really trying to bring this indictment into conformity with what they can glean from the Supreme Court's decision on immunity. And so they've focused on the areas where the Supreme Court provided some guidance. For example, they got rid of any kind of allegations involving former President Trump's communications with his own Justice Department or his own executive branch, because the Supreme Court said that's within his constitutional authority. He's absolutely immune for that. But for other areas, such as his pressure on Vice President Pence, his pressure on state legislatures and state legislators, and his statements to the public, they eliminated some things and they added some things. And in particular, they focused on the fact that the allegations that involving Pence involve him in his role as president of the Senate, which is an Article I role, which is not an executive branch Article II role, to say when he's pressuring Mike Pence about the certification of the Electoral College ballots, he's doing that while Mike Pence is in a role outside the executive branch, and it's a role that the president, Mr. Trump at the time, had no official responsibility for. Similarly, in other areas, they make clear that Trump was acting as a candidate, not as a president. For example, in some of his interactions with state legislators and state officials, and his getting behind the fraudulent elector scheme. Similarly, with his tweets and public statements, they've alleged these were done, as you just indicated in that excerpt, in his personal capacity or as a candidate. And they always refer to the January 6th speech on the ellipse as a campaign speech, and even make clear it was privately funded and privately organized. These are all things to try to put them on the side of unofficial acts or rebutting presumptive immunity of official acts, as the Supreme Court outlined.
So as a former prosecutor and as a former acting assistant attorney general for national security, talk to me about how this case proceeds and doesn't become about endless interpretations of the Supreme Court's decision about official acts as opposed to the underlying matter. Because I can see Donald Trump's defense calling, litigating all of that stuff, whether it was official acts or not, because that is ultimately, given those charges, their best chance of success.
Yes, ordinarily you'd really kind of take the indictment, which again, this time, this superseding indictment was returned by a new grand jury, not the same one that had heard evidence. They heard it all over, so there was no taint from the previous grand jury. And you would normally sort of look to those allegations and assertions and sort of accept those. But this is a different world because we're talking about immunity of a former president after we have a Supreme Court decision. We'll know more Friday when the parties are supposed to submit their joint proposal to Judge Chutkan, the district court judge who now has this case back in her court. They are supposed to be proposing next steps. But I think you're right. I think that Mr. Trump will be trying to argue that these things, these changes that Jack Smith made in this new indictment don't eliminate the problem of official, unofficial, and they will want to litigate. They will want to file legal briefs, etc. What they will not probably want to do, Mr. Trump's attorneys, is really have evidence on that. And Jack Smith may say, well, for some of these things, if he's contesting these, we may need some evidence.
This thing that we're going to hear about on Friday, it's called a joint status report. Is there some sense that Donald Trump's team at least agrees that this new set of indictments is cleansed of the things that the Supreme Court is saying, or we just don't have any insight into that yet?
I have not yet today heard of any statements coming from Trump's legal team or even, frankly, from his campaign, but I haven't looked for any campaign statements. And I would just be surprised, based on the way his legal team has litigated all of his other criminal and civil cases. I would be surprised if they agree to very much here. They will probably agree that things were narrowed, and they will say it was good that Jack Smith eliminated the entire section of the indictment that relies on the pressure of his own Department of Justice and his own Attorney General. But I think they will seek to really argue about some of these other areas. And I think it's likely the judge will first have legal briefing on that before she makes any decisions about whether any kind of factual development through evidence is necessary.